When can you modify your visitation schedule in Oklahoma? I'm Tulsa attorney James Wirth. That's the question that we have. And it goes mostly to this case from the Oklahoma Court of Civil Appeals, Swiney v. Villanueva. It is 2021 OK CIV APP 37, and it deals with what is the standard to modify visitation. For modifications, when we're talking about kids, normally we go to one thing, and it's the Gibbons standard. And that's what they were trying to push for in this case. The Gibbons standard says that you can modify when there's been a substantial, material, and permanent change in circumstances which directly affects the best interest of the child to where the child would be substantially better off if that change were made. So it can be a high standard to make. We've got to look at once after the last order was entered, what has changed, and that change has to affect the best interest of the child to make it in the best interest of the child to do a change, and it has to be substantially better off, and it has to be substantial, material, and permanent. So does this standard apply when you're requesting a modification of visitation as it does to other types of custody modifications? And that's the question that came before the court. And ultimately the court said that there's no case law in the state of Oklahoma that has ever said that the Gibbons standard has to apply to visitation. What it says is that Oklahoma statute in Title 43, Section 112A3, grants the trial court the authority to modify visitation whenever the circumstances render the change proper. So it's a lower standard than what we're talking about in the Gibbons standard sometimes. So the facts in this case deal with a father who there were some concerns regarding his parenting. He was granted maybe some supervised visitation, and there were steps he was supposed to make. So the judge ordered he complete A, B, and C. The dad then completed A, B, and C, goes back before the court. He demonstrated he completed A, B, and C, and the other side was, well, you may have completed those things, but that doesn't show that it's a substantial, permanent, material change in circumstances that means that the kids would be substantially better off with you having more visitation. So under the Gibbons standard, he would lose. But what it said in this case is that the judge laid it out, anticipated that there's going to be a modification when he completes these things. So it's not the Gibbons standard that has to be proven here. It is just this statutory standard that says that there's the authority to modify visitation whenever the circumstances render the change proper, and here the change is proper. So what you need to know about modification of visitation is that you still need a change, and you still need to demonstrate that the last court order may have been perfect then. The court's always going to assume their orders are perfect. It was perfect then, but it's no longer perfect now because things have changed. But you don't have to reach that higher level that says that it's a permanent, substantial, material change that makes it substantially better off for the kids to do something better. So if you're dealing with this circumstance where you're wanting to modify visitation, or if you're contesting the other parent's modification of visitation, this is good information to have, but it's probably not all you're going to need. You're going to want to talk to an attorney privately and confidentially to receive legal advice specific to your circumstances. To do that with my office, you can go online to makelaweasy.com.